Ready?
All right, well, looks like people are still joining the webinar, but it's shortly after 11 o'clock Eastern Standard Time. So I think we should get going while people continue to sign in. Anyway, thank you for joining today for our webinar, Navigating the Future of AI, a comparative discussion on the EU AI Act and US AI legislation. Today, we will be discussing the evolving landscape of AI regulation, focusing on the pioneering efforts of the European Union and the landscape emerging here in the United States. My name is Matthew Cole. I'm a partner in Baltimore's litigation group. I sit in our Baltimore office, and I am pleased to be doing this presentation today with Anne-Marie Pecoraro, who is a partner at UGGC Avocats, and she's an attorney in France and specializes in IP, AI, and data privacy, and Adeline Perron, who is a co-founder of the Elix Foundation. Before we begin, just want to make a couple of housekeeping announcements. As to Q&A, questions can be submitted through the Q&A tool at the bottom of your screen. While we'll do our best to answer all of your questions during the webinar, if we've run out of time, we will follow up individually via email. As far as CLE, today's program is eligible for one substantive CLE credit in California, Delaware, Florida, Georgia, Illinois, Minnesota, New Jersey, New York, Ohio, Pennsylvania, Rhode Island, and Virginia. As a CLE provider, we must be able to verify your attendance. So at random points during the webinar, we will display and verbally announce two numeric reporting codes that you must record and report back to us using the survey that you will receive in your webinar reminder. Be sure to respond to the Saul Ewing CLE survey with your numeric codes within 5 days of the program. Following the webinar, you will receive a follow-up email that will include the links to the webinar recording, supplemental presentation materials, and CLE information. And the provision and receipt of the information in this program is not legal advice, does not create a lawyer-client relationship, and should not be acted on without seeking professional counsel who have been informed of the specific facts. All right, with that, let's begin. So next slide, please. So before jumping into some of the substantive discussion, I thought it would be helpful just to lay out some of the AI terminology, and we're not going to go too deep into this, but just to give everybody a sense of where we're heading today, right? So artificial intelligence is essentially computer systems, software systems, robots that mimic humans' intelligence in that it can learn from data, make recommendations, draw conclusions, identify signals and patterns and large quantities of information. Generative AI we'll talk about a little bit today, although the focus is going to be mostly on algorithmic decision-making tools. But generative AI is a type of AI tool that can create new content, right? That mimics human output. You put in an input, often a written prompt, and you get some kind of output. And it can be text, it can be audio, it can be video, it can be a combination of the two. It can be software code, for instance. An algorithm is just a set of rules designed to solve a problem. You may have heard that term quite a bit, but think about it as instructions given to a computer system to analyze the data that it's been trained on and provide some kind of output for the user. An automated decision-making tool or an algorithmic decision-making tool is an AI system that may make a decision without human involvement, but also be aware that an ADM may work without using AI. So you've probably seen in the news quite a bit of discussion about algorithmic or automated decision-making tools. And then bias is something we're going to focus on today as well. And there's a couple ways of thinking out bias, but one sort of broad way of thinking about it in terms of at least AI is a deviation from an expected standard or an expected result. And for legal purposes, we're going to look at bias in the lens of a lack of fairness in the processes that could result in harm to the individual or groups. Next slide, please. And here's just sort of a general overview and agenda for the CLE portion of today's presentation, right? Anne-Marie is going to go into detail on the EU AI Act, and we're going to talk about, I'll talk about some of the distinctions as what's happening in the US. And with that, next slide, please. And Anne-Marie, please take it away.
Thank you, Matt. I'm Marie Pecoraro from UGGC Avocat, a full-service law firm. We work from Paris, Brussels for EU matters, and Casablanca. We specialize indeed in intellectual property and digital law, as Matt said. So today we will dive together into a summarized comparison of the regulation of artificial intelligence in Europe through the AI Act and regulation in the US. The EU AI Act is the first international regulation and offers a unique law for the entire EU. The Act will set harmonized rules that will apply among the 27 EU member states uniformly. It will ensure a consistent legal framework in all member states. It has, this is the important point, it has an extraterritorial scope because it applies to providers placing on the EU market AI systems as well as providers of AI systems living outside the EU but whose products produced by the AI system are used in the EU. So we will develop this later on. But I underline the extraterritorial application. We had a legal framework pre-EU AI Acts, because before the Act came into effect, France and the EU has already some limited number of regulations trying to tackle the different legal issues around AI systems. Here are a few examples. First, you all know the GDPR, which came into effect in 2018 and is still applicable. The GDPR is applicable for tech processing personal data. It imposes obligations regarding consent, transparency, and users' rights, such as the right of access or rectification. So it was already a major step into regulating the processing of personal data that could also come from AI systems in the EU. We have a group of extraterritorial texts with the GDPR, the DSA, the DMA, the Data Act, and the Artificial Intelligence Act, and some other acts applying all over the world. Another text important with respect to copyright infringement is what we call the text and data mining exception. It will depend upon the time we will have or your question to see if we develop more this aspect. But in a nutshell, the text and data mining exceptions, TDM, were introduced in the directive on copyright in the digital single market. The directive introduced two mandatory exceptions under EU copyright law, which require member states to provide for an exception or limitation for reproductions and extractions of work on other subject matter without copyright owner's permission for the purposes of text and data mining. The link here, so the text was 2019, before the AI Act, but the link here between AI and these TDM exceptions relies on the fact that AI, especially in areas like machine learning and natural language processing, depends heavily on the ability to process large amounts of data, text, images, to learn patterns and improve their performance input. The TDM exceptions under the CDSM directive enable AI developers to legally mine large volumes of text and data, such as books, articles, reports, or online contents for training purposes without infringing on copyright, provided that the data is lawfully accessed. So we have two exceptions. Article 3, Directive Article 4. The Article 3 is the TDM for scientific research. The exception concerns commercial and non-commercial uses alike. The beneficiaries of this exception are research organizations, which is in fact understood as being universities, research institute, non-profit, public interest, and so on. The other one, Article 4, is the TDM for any purpose. But this exception is subject to the opt-out, the ability for copyright holders to opt out of that exception and expressly reserve the use of protected words. This is a very large topic, so this is why I suggest that we move forward for the moment and we can go deeply in the exceptions and how the opt-out may work later in our session. So what happened with respect to the legal framework pre-EU AI Act? So we have also to take into account, more generally speaking, the French civil liability law, which may be applicable. For example, if damage was caused by an AI system, the principle of liability for fault or liability for damage caused by things could potentially apply, despite it would be probably a difficult case for building the file and the proofs. We had also a law called the Law for Digital Republic. It created a legal framework for the development and use of digital technologies in France, focusing on transparency and access to public algorithms. Although it's not specifically focused on AI, some of its principles address relevant aspects, such as the transparency of automated decision in the public sectors. We also have a national agency for the security of international systems. We had several reports and sector-specific regulations, such as the e-privacy directive, the medical device directive, the product liability directive. And now happened the AI Act. It was published on July 12, 2024, in our official journal, making it the first comprehensive, ambitious, horizontal legal framework for the regulation of AI systems across Europe. It was negotiated between the several stakeholders of the EU with Commission, Council, Parliament during the past 3 years. So here is the logic. The purpose of the AI Act is to ensure a high level of protection of health, safety, fundamental rights, including democracy, rule of law, and environmental protection against the harmful effects of the AI system in the Union. Again, the approach we may often have about the AI is to see it as an opportunity, something we can't avoid, but also an opportunity of development, of development for the EU economy, but also a risk if it's not regulated. So the balance to find is still to regulate it, but to let some open avenues for development. The approach to AI is not only protecting and ensuring a safety regulation, but also a life cycle approach. The AI Act regulates according to risk, pre- and post-market monitoring. It looks at the risks through the whole life cycle of a product. The AI Act aims to facilitate trust through the entire value chain. And it also encourages the development of trustworthy and human-centric AI, which is a very important word. So it will contribute to the new legislative framework system. It means it's without prejudice to existing union law, in particular on data protection, fundamental rights, employment, protection of workers, product safety, to which the new regulation is complementary. And we will see that if we take the time of a focus on data protection, personal data protection, and copyright, there is really a robust coordination between those different texts. So for the timelines, summarized timeline for the EU AI Act, it will be a progressive compliance to put in place. It means that the company will have to develop a compliance program, starting with the most serious risks and prohibited practices. That ban, because we have a ban, will come into effect in February 2025, so in a few weeks only, with a ban of some of the practices. And the European Commission will publish guidelines to complement the text and enable its application, including compliance obligation. I started mentioning earlier the extraterritorial scope because the AI Act is of particular interest not only to us, Europeans, but also to countries outside the EU because of this scope. The Article 2 mentions that the Act applies to providers. So in the Act, you find providers, you find deployers, you find users. Now we talk to providers placing or putting into service AI systems on the EU market, irrespective of whether those providers are established or located within the Union, as well as providers of AI systems living outside the EU, but where the output produced by the AI system is used in the Union. Therefore, for companies located outside the EU, for instance, American companies located in the US, but that offer AI system in the EU market, or whose AI systems affect individuals within the EU, then the EU AI Act applies and involves very specific compliance obligation on their part. For those companies, several obligations will apply, particularly if for the system falling into the high risk category. So now we give a few examples we will develop after. Data requirements. This requirement is for all developers. International companies must ensure that the data sets used in the development of AI are free from bias, are accurate, representative, particularly for high-risk application. That it was first data requirements. A second, risk and impact assessment. Risk and impact assessment is mainly for developers of high-risk systems. Companies must perform risk assessments of their AI systems and regularly audit and monitor their performance, ensuring they comply with safety standards and do not infringe fundamental rights. So for this, the teams of the company working with the attorneys and the lawyer will have to build a process inside their teams for this monitoring. Then third point, compliance and documentation, also for all developers. Companies will need to create a comprehensive compliance strategy, including technical documentation about the AI system's operation, information on how data is collected, processed, and stored, strategies for data governance and handling potential risk. Again, another point, the post-market monitoring, confirmed for developers of high-risk system and to be confirmed for others. So the companies will have to monitor their AI system continuously after deployment to identify any new risk and report major incident to authorities. Transparency is more and more an important word in digital law. And explainability for everybody, for all developers. For some systems, the companies must ensure that the AI's decision-making process can be explained to users. In particular, high-risk systems must provide an explanation of how decisions are made. So if we take another view, the AI Act is a system based on putting into place obligation for progressive compliance, starting with the most serious risk and prohibited practices. So let's go. I think we can go directly to slide 9 with a diagram in form of a pyramid explaining the different categories of risk, and then we will go back. The word risk means the combination of the probability of an occurrence of harm and the severity of that harm. Types of risk covered by the AI Act, providers will have to cover health, safety risk, and risk to fundamental rights. The majority of obligations that are talked about in the AI Act fall upon providers, so what we also call developers here of the high-risk AI system. So these are the systems that are the most regulated. Users of a high-risk AI system have some obligation as well, and deployers. High penalty plan for deployers and users that do not comply with the AI Act. The financial penalty can go to 35 million euros or 7% of worldwide annual turnover, whichever is the higher. So let's see, focus maybe on the question of the biometric identification. The biometric identification has been a topic of discussion amongst European institutions, especially in light of the recent Olympic Games of Paris 2024. The EU Commission position on biometric identification is to prohibit the use of real-time remote biometric identification unless certain conditions were met. It was also the request of the French government to keep some conditions to allow the biometric identification. However, the EU Parliament's proposal on biometric identification was stricter and asking for a complete ban on biometric identification without any exception for it. So during what we call trilogue is a discussion in the EU between the EU Commission, the EU Parliament, and the EU Council. The three institutions try to find a meeting point between the Commission proposal and the Parliament position. And now the current Act prohibits, in principle, the use of biometric identification systems, except in an exhaustively listed, narrowly defined situation, which are mentioned linked with security. So real-time reboot, biometric identification system are authorized only when, so we will find a list related to security. For instance, prevention of a special, substantial, imminent threat to the light or physical safety or natural to the compromise found notably with the French government. Now we are on the pyramid of the risk-based approach to build the compliance gradually. So at the top of the pyramid, prohibited practices. The AI Act plans in Article 5 the prohibition of some AI system. The ban concerns AI systems capable of subliminal manipulation, exploitation of vulnerabilities of persons resulting in harmful behavior, biometric categorization of persons based on sensitive characteristics, general purpose social scoring, real-time remote biometric identification in public space, scrapping facial images. So it's important to keep in mind that all those practices are strictly banned, will be strictly banned in the EU. Complete and total ban for the services. Infringing the ban will lead to severe fines and restriction. Then we have the high-risk AI system. The high-risk are not prohibited, but regulated. And you will find some area, current areas such as human resources practices, including in high-risk AI system. They are strictly controlled. So the system that face stricter obligation are, for instance, to give an example, are AI system used for biometric critical infrastructure, education, employment, essential services, law enforcement, migration, and justice. Obligations are heavy for provider and user developing and using a high-risk AI system, and again, they will have to build process for their compliance with all their team, the tech team, the legal team, notably. First of all, the deployer must proceed in a conformity assessment, and the assessment needs to be repeated, of course, if the system is modified. So the term conformity assessment is defined and means the process of demonstrating whether the requirements relating to a high-risk AI system have been fulfilled. In other terms, on top of being compliant with a list of union harmonization legislation, providers must put into place risk management system, and this is mandatory with data governance, technical documentation, cybersecurity measures, and so on. The University of Oxford has created a tool called CAP AI with a procedure for conducting conformity assessments of systems in line with the EU AI Act and coordinating, as I said, the teams of a group. So a little focus on the risk management system. The high-risk AI system shall comply with the requirements laid down in the text, taking into account their intended purpose. And then it's a system that covers all stages of the life cycle with obligatory testing, and it must be adjusted with post-market monitoring. So there is an obligation to set, to implement, to document, and to maintain. And the concept is the continuous process. It runs through entire life cycle, comprising the following steps: identification and analysis of the known and reasonably foreseeable risks that the high-risk AI system can pose with health, safety, fundamental rights, estimation and evaluation of risks based on data from post-market monitoring, adoption of appropriate and targeted risk management logic measures, and identifying most appropriate risk management measures. And then the following must be ensured: safety by design, protective measures, information for safety. And the providers need to test. Testing shall ensure compliance. Testing is fundamental. It's the key to understand how it works. And then it leads us to the quality management system. So it's used to designate the level of safety and the other public policy objectives which are aimed by the EU legislation in its guide. So it's mandatory, it must be documented, it covers quality during the whole cycle products, and high-risk AI system that are deployed by public authorities or entity acting on their behalf, in addition, will have to be registered in a public EU database unless those systems are being used for law enforcement and migration purpose. So then you had the forbidden and the high risk. So for instance, if a company develops a H&R system for recruitment, it will be a high risk, so it will have to comply with everything I just had described, and then it will be able to be used in the EU. The next step is the specific AI system. So what are the specific AI systems? This is systems that are used to interact directly with human beings, such as chatbot on websites, deepfakes, or more generally, generative AI systems such as ChatGPT, for example. So the deployers of those kind of AI, specific AI system, must inform people that they are interactive with an AI system, unless it's really obvious from the point of view of the user. The idea of being obvious already exists in the French law, where we already punish the deepfakes unless it's really obvious that there is good reason, but it has to be obvious. So we write it like this. We already have it in France, but we are not really sure what obvious will mean in any circumstance and in all the countries. So it's always better to let the user know that they are facing an AI system for more security. Transparency obligation fall upon deployers of those kind of AI. Then we go to the minimal risk AI system. The minimum risk, not referred to as such, but it became the common name of those AI systems, are actually all other AI systems that do not fall under the other categories. This includes applications such as AI-enabled video games or spam filter, and the AI Act doesn't impose specific obligation for those AI systems. And then you have also the general purpose AI system. This is a new category, models that have you often read about those category in the newspaper or in anything happening in this area. Those are the models that have high impact capabilities determined by technical tools and benchmark. So they use a large amount of computation for its training and have high impact capabilities. So those general purpose AI systems see to be included in the match with the generative AI system. So the goal of a general purpose AI category is to refer to artificial intelligence systems that are not designed for a specific task, but can be adapted for a wide range of applications across various sectors. And the goal is to regulate some AI that could have broad and diverse impact, regardless their initial purpose. So it's very, very large. And it leads us to IP issue. And depending upon your question, I would be happy to develop all the details about the IP protection question. So in the AI Act, the providers of general purpose models must have a policy to comply with EU copyright law, including complying with the opt-out rule that I've mentioned before, which allows owners of IP rights to back out or opt out when they do not want their creation to be used as input data in an AI system. So it's difficult to put in place, and we already have a case. I will mention it later. And the other thing is that the other thing is very important because it has been long negotiation with the right holders. The providers must disclose details of the content used for training, and no exception is made for open source models. So it's really a huge thing in one sentence. It means that the public, the companies, right holders will be able to ask to the providers to give a summary detailed on the content of the input. Very important sentence, but how it will work, we don't really know for the moment, but it means that the documentation about the input will be incredibly important. And with respect to the opt-out, there is a case in Germany, in the Hamburg district, and we don't have yet the decision. I think that the judgment will be released in the next few days. So this is Lion versus Kneschke. So this is the third time there is a problem about such analysis about the TDM, because an artist put an opt-out and the creation were used as input. And then Lion, the AI system, said the opt-out was not in a regular form, because in the directive and in the laws implementing the directive, the opt-out must be readable, technically readable by the machine. So if an opt-out is not enough understandable by the machine, then we don't know yet if it can be taken into account or not. So this is the case with the first German case. We will know in a few days or weeks what is the solution of that main question. Is the opt-out compliant? And does it mean the requirement of being machine readable in that case? And if it's not machine readable, probably the opt-out will not be valid.
Anne-Marie,
Yeah.
I just want to jump in to make sure we give the first CLE code to everybody, and it's on slide 18, and that first CLE code is 13579. I just want to know we're starting to run close to the hour.
Okay, thank you. I was about to give it, but thank you to do it now, Matt. So some an important principle, as I said, being able to give the detail of the content. Another one is the trade secrets, because giving the details is not positive for the industry. So notably the French government, they negotiate to obtain some protection, and then they obtain the word trade secret in the directive. So we find in the directive the protection of the trade secrets, and this is when we arrive in bias and discrimination. Matt, I don't have really finished, but I don't want to take too much of your time. So what do you think if I stop here, and then maybe you can take the floor, and if we have more time, I can revert to the slide, to the IP, to the opt-out after, as it's time now.
Sure, that sounds great. So could we please go to slide 20? Thank you, Anne-Marie, for that presentation. That was very insightful. And I will talk a little bit now about the emerging US framework. So around 11 months ago this time, actually on October 30th, 2023, the White House issued its executive order, which really wasn't a law. It's not technically binding on companies, but it really laid out its concepts and some directives to agencies to develop guidelines, standards, and best practices for AI safety and security. And in that time, companies the government has been doing that, trying to develop. NIST came out with the risk management framework, for instance. So there's been a lot of effort towards developing guidelines and standards to protect individuals and the public at large, to mitigate harm. And some of the focal points of the executive order were maximizing benefits for workers and protecting threats against critical infrastructure, such as utilities. But in that time, right, lawmakers and regulators have taken action and been very active in the space, including filing lawsuits, bringing enforcement action, enacting and passing a variety of bills. And really, where has, in my opinion, the focus of US regulators and lawmakers been? It's been in three topics: bias and algorithmic discrimination and access to what are described as important or key services, right? Employment, education, financial services, healthcare, consumer protection, protecting individuals and the public against a misleading description of AI or abuse of use of AI, and then data privacy and the rights of individuals. Next slide, please. And so the comparator, the similar statute to what's going on in the EU is Colorado's AI Act, right? It's the first and only comprehensive US legislation passed in the US so far. It, like the EU AI Act, is risk-based, and it tiers the risk. And the focus, much like in the EU, is on high-risk systems right? Those that can result in the denial of important services to consumers. And those are educational and employment opportunities, financial and lending services, and another example are healthcare and insurance. And it's a very similar scheme to what is going on in the EU, where developers and deployers must use the term as reasonable care. That's the standard that's in the statute to protect consumers from known or reasonably foreseeable risks of algorithmic discrimination, right? So the concern is decisions being made that can affect the rights of people. So for instance, people applying for a job, if an AI tool is reviewing resumes or ranking resumes, or people applying for a credit card or to open a bank account or for health insurance, where an AI tool might disqualify them, right, based on some protected trait or characteristic, such as race, gender. And so the Colorado's AI Act is aimed to prevent or mitigate those kinds of risks or prohibit those kinds of risks. And, for instance, using zip code, right, as a proxy for location and things of that nature, really trying to avoid discrimination based on protected class. And then AI deployers must conduct AI impact assessments annually. So an AI impact assessment is basically more of a process than a thing. I mean, it involves using a questionnaire, but it looks at the purpose, the risks, and the potential benefits of the AI system before, ideally, a company decides to develop, design, or deploy an AI tool. And it's a very comprehensive analysis. It requires an investigation involving typically people from different functions within a company, of course, legal, privacy, possibly HR, and where documentation is gathered and maintained, and then a determination is made, should we deploy this AI system? And if so, can we mitigate the potential risks that we've identified in any way? Is the AI system customizable? Is it not, et cetera, et cetera? Next slide, please. And so a lot of these laws, right, Colorado's got sort of a general purpose comprehensive statute, but in the US, there have been laws that have been passed on specific topics, and employment protecting, against the use of AI in employment decisions is one of them. And that's not just hiring, but it can also apply to job promotion decisions. And it's not just limited to, for instance, the AI being used in the final decision, but during the entire hiring, right, or job promotion process, the employment process. And so a good example of that is New York City's local law 144. And it's a very different kind of law than the Colorado law because it requires a bias audit, which is something different than an impact assessment. And I sort of like to think about things at least in terms of the chronology of when you're going to utilize these tools, right? Ideally, you'd use an impact assessment prior to deciding to deploy an AI system, right, to determine the purpose, the risks, and the benefits. And a bias audit serves a different purpose. It determines if the AI tool is working as planned, right? You look at the results and you say, all right, let's analyze the results. Can we identify any discriminatory output? Is it doing anything to mitigate that, et cetera, et cetera? So bias output is the post-marketing monitoring that Anne-Marie described, right, that under the EU AI Act. And the New York law has notice requirements, right? Employers must give notice that their AI tools will be used and provide a summary of the audit, the bias audit on their website. Employers can do that, for instance, if they have on their website an employment tab where you can put all the required information. The local law doesn't really give a lot of guidance on what the bias audit should show, what results are acceptable, et cetera, but they have to be conducted by an independent body. So for instance, if you're developing and then deploying your own system that you designed yourself, right, you're probably going to need to go out and get a third party to do the audit for you so they can give you an independent overview of the results and make sure that you're complying with the law and not sort of improperly discriminating against any individuals in the hiring process. Illinois has an AI Video Interview Act, which is a little bit different, right? You have to, again, notice, of course, is a key provision. You have to notify applicants that you're using AI, explain how the AI tool will evaluate the applicant's characteristics, and obtain the consent. An applicant can opt out, request the destruction of video interviews, and you have to provide an annual report on the demographics of the applicants who are, one, offered an interview, not offered an interview, and those who are hired when the AI tool is involved. And more recently, Illinois amended Human Rights Act to prohibit algorithmic discrimination in employment decisions based on protected class, unlike the Colorado Act, which requires, right, impact assessments, and unlike the New York City local law, which requires a bias audit. The amendment to the Illinois Human Rights Act doesn't, by its terms, require either, but at least an impact assessment, right, is a best practice that a company should utilize before deploying an AI tool. And then, obviously consider doing a bias audit after it's in operation. Next slide, please. And here's some other other AI laws that are interesting. California, over the summer, California's legislature failed to pass what was Assembly Bill AB 2930. And much like the Colorado AI Act, it's a comprehensive act that prohibits algorithmic discrimination, right? This bill prohibits an AI system contributing to unjustified differential treatment or impacts disfavoring people based on various protected characteristics. And similar to the Colorado Act, right, employers, if this law goes into effect, and it's most likely going to come up again next year, employers must conduct impact assessments, provide notice of AI use, and implement governance programs and technical protections. And Anne-Marie talked about having a robust governance program, how that's required, right, by the EU. And that's going to be required, right, if this law passes in California, and any company that is designing or deploying AI should, in any event, have a robust governance program with written policies. And I'll give some key takeaways, in my opinion, on what a governance policy should include. And going back 4 years, Maryland, my home state, and give it a little bit of a shout out, has had a law prohibiting against creating facial recognition templates during an applicant's interview with AI unless the applicant consents in writing by signing a waiver. So the laws in the employment space vary. The focus is, of course, protecting people's rights to gain employment, get promotions, and really a lot of the newer bills are focused on prohibiting algorithmic discrimination when automated decision-making tools are used. Next slide, please. And so here are some takeaways on common legislative themes in regard to algorithmic discrimination, right? The burden and potential liability is on AI deployers, not just AI developers. So if you are licensing an automated decision-making tool from a software AI developer, right, you could be at risk if, for instance, there is a discrimination issue. You have to implement governance policies, and impact assessments may be mandatory, right? If you're in Colorado, California, an audit may be mandatory if you're in New York, but again, they are best practices. Certainly impact assessments when you are thinking about designing or deploying an AI tool, right? You have to provide notice and disclose the use of AI to potentially affected individuals, those are applicants, right? And provide the right to opt out of AI use. And what does this really mean, right? It really means having a formalized approach to managing AI risk, right? Understanding, is this the right tool for the job? Do we want to undertake this use case? And what are all the obligations that come along with it? Next slide, please. Okay, so I'm going to talk a little bit about some litigation in the employment space involving at least algorithms, right? Last May, the EEOC issued guidance, and it was very clear that employers are responsible under Title VII for the use of automated decision-making tools, even for tools designed by another entity, right, such as a software vendor. So they've made it abundantly clear. And then so last year, how did the EEOC sort of act on their directive? Well, they filed an action against a company called iTutor, in which it was alleged that there was algorithmic discrimination. Now, AI and machine learning wasn't clearly alleged in the EEOC's complaint, but they did talk about automated decision-making tools being involved. And so what happened there? So a woman applied for a job, right, put all of her information in, including her birth date, and she was rejected and did not get an interview. Well, the very next day, she reapplied for that job with all the same information, except she put in a birth date that made her appear younger, and she got an interview. And so that's why the EEOC filed this action, because they were alleging discrimination based on age. So ultimately, the case settled, and as part of the settlement, the employer had to pay $365,000 to the approximately 200 applicants who were rejected based on their age. So pretty significant consequences. The EEOC is following this very carefully. So, if you're going to take on and use an ADM and AI tool for decision-making and employment practices, make sure you have a well-documented governance program, you're doing impact assessments, and you're taking all the steps to mitigate the risk of an unfair discrimination. Next slide, please. Here's a recent decision in a case in California. Here, a company sued the software company Workday, right, alleging that its tools discriminated against race, age, and disability. And here they weren't necessarily suing the employer, but suing the vendor providing the AI tool. And on a motion to dismiss, the court denied it and found that the plaintiff adequately alleged that the customers delegated traditional employment tasks to Workday, and found that Workday was an agent of the employer because its tools performed a traditional hiring function of rejecting candidates at the screening stage. So whether you're an AI developer, like a Workday, or an AI deployer, such as an employer, you have to be very careful because discrimination is being looked at very carefully by the EEOC and by plaintiffs and by the states. Next slide, please. So here's some other industry-specific laws in the US. You may be familiar with what's going on in New York, particular to the insurance industry, right? So earlier this year, New York sort of formalized its insurance circular letter number 7. And this rule applies when an insurer uses AI, or something known as ECDIS, external consumer data and information sources. So things like social media feeds, right? Looking outside of the traditional underwriting information to gain information on an applicant. And it only applies when AI or ECDIS is used in the underwriting or pricing, to make underwriting or pricing decisions. And it prohibits unfair and unlawful discrimination based on protected class. And much like the New York City Local Law 144 here, the New York Circular requires AI system bias testing and validation, right? So making sure, once again, that the machine, the AI tool, is doing what it's supposed to do after it's been deployed and in operation. But of course, any good best practice, right? You do your impact assessment and try to get as much information about the AI tool in the procurement diligence process as you can, right? And of course, this statute has notice provisions like all the other ones we're seeing in the US, where insurers must disclose and explain adverse underwriting or pricing decisions to applicants. Another interesting law in the US is the Utah statute, which is really focused on Gen AI. It's a little different than what we've talked about so far, but this applies to regulated occupations, right? And that sort of is very broad, and Utah has a website that identifies what its regulated occupations are, and it's everything from accountants to healthcare professionals, to cosmetologists, to the contractors who are going to come work on your house, right? And so regulated occupations must prominently disclose that a customer is interacting with generative AI, and most likely a chatbot, and you cannot avoid liability by blaming the chatbot for a adverse action, a discriminatory output, binding you to an agreement like we saw in Canada last year, where some people sued Air Canada, and the court ruled in an arbitration that the contract made for highly discounted prices on tickets provided by a chatbot. Well, Air Canada had to live and die by its chatbot, and we're seeing the same thing here in Utah. Next slide, please. And so another focus is consumer protection, right? Regulators have been very busy, and they're utilizing existing consumer protection statutes, including this year. We've seen a lot of action just in the last 6 months, right? And so one of the key terms here is AI washing. And, that's just basically misleading about how you're using AI, right? Vague or inflated claims about AI use to boost your brand, get investors, get customers, gain a competitive edge in the marketplace. Well, earlier this year, the SEC settled with 2 investment advisors who agreed to pay $400,000 for making false and misleading statements about the use of AI in their investment selection. And just a few months later, the SEC filed a securities fraud claim in the Southern District of New York against a former owner of a company for misleading investors and disclosures, right? Securities disclosures, I believe it was a privately held company, about how its AI platform worked, its use of machine learning and algorithms. And interestingly enough, right, it wasn't just the SEC, the DOJ was not messing around either, because they filed an indictment that very same day in the SDNY for securities and wire fraud. So serious business. If you're going to be misleading, make misleading claims about AI that your company is using, right? The EEOC, the SEC, and we'll talk about it in a second, the FTC is watching as well. So next slide, please. Right, and so The FTC is also been very active, and so we don't have a few minutes. So I'm just going to talk about these generally. Like last year, for instance, the FTC brought an action against its Amazon-owned Ring doorbell company for violating data privacy laws by collecting consumer data and not giving the consumers a proper consent or opportunity to opt out or have sufficient control of their data, right? And so the data was being used to train algorithms, and consumers were just unaware and not given a full, meaningful opportunity to opt out. And so what happened? Ring settled with the FTC for more than $5.5 million, and had to provide customer refunds. And earlier this year, the Massachusetts State Attorney General sent out an announcement, basically a letter saying like, we are going to focus on companies that use AI externally with customers. And don't worry about the fact that we don't have an AI-specific law in the Commonwealth of Massachusetts. We are going to rely on the Massachusetts Consumer Protection Act and other applicable federal and state laws. So where some of the laws that we've seen might be like gap fillers, like the Utah Gen AI Act, right? Regulators are going to rely and have been relying on existing statutes, such as 10b-5, right, for the SEC and the FTC Act. Next slide, please. And so California, before we dive in here, I will give the second CLE code for everyone playing along at home, and that is 29831. The second code is 29831. California, I think this year had at least 10 bills concerning AI. Some of them passed, some of them did not, but they've also been focused, as always, on data privacy. And so here are some of the bills that I believe have not been signed by Governor Newsom yet, but could very well be the law in California soon. And so these are very interesting, right? These are a different take, not focused on algorithmic discrimination, but really focused on data privacy and supplementing or amending California's privacy statute to really broaden it, right? And so the first one here, just for everyone, is AB 2013, right? The AI Training Data Transparency Law. It applies to Gen AI developers, right? Who will have to publish information about the sources, owners, purposes, and IP rights of training data, right? Because there's a lot of lack of transparency about what's in training data, both through as its quantity and its quality. And for companies developing large LLMs, right, they're going to have disclosure obligations to explain to the public, is PII in our training data? Is IP in our training data, right? Where are we getting it? Are we properly licensing it? So there's going to be a lot of disclosures about that probably coming shortly. I don't think California is going to be the only state doing this. Assembly Bill 1008 makes personal information in AI systems subject to California's privacy statute's obligations, right? So some examples are the obligations of data minimization, responding to consumer requests. So once again, right, verifying if you're using an AI system, if you're developing it or licensing somebody else's AI system, or just licensing or acquiring data to train an AI system, you want to make sure that you have verified the quality and accuracy of your data, because if somebody says, hey, I would like to correct, right, the right to correct is a right of a consumer to change something, and you've trained your system on it, it's going to be very, very challenging, if not impossible, to modify or detrain. There's a term I've been hearing a lot recently, an AI system with erroneous information or information that somebody says, please delete, right? Because they have the right to be forgotten, for instance. And here's a really interesting statute. The last one here I'll talk about on this slide is AB 3204 for companies that are data digesters, right? They must now register with California's Privacy Protection Agency. And so a data digester, it's a defined term in the statute. It's a business that trains AI with the personal data of more than 1,000 households. So it's a very low threshold. And training data metrics will be published on the CPPA website, very similar to the publication requirements on AB 2013. Next slide, please. And so here are some key takeaways for deploying AI in the US, right? Sort of aside from the statute, which is good things to think about when if you want to use AI, right? Anna Marie emphasized this, and I will do the same. A robust AI governance plan is important, right? And it typically has a cross-functional AI task force, a working group, committees, et cetera, right? There is no sort of one-size-fits-all approach. It really is based on your company, how they intend to use AI. Technical involvement is key, right? Have your CTO, have your information security people involved, have your privacy people involved, have very knowledgeable subject matter experts at the table talking about a governance plan, and of course, implementing a written risk management framework, right? A well-drafted AI policy should identify a use case, what's permissible, what's prohibited, stress the importance of privacy, IP rights, and of course, discuss accountability for individuals that misuse an AI system. And then, of course, the importance of AI system diligence, right? Impact assessments before deploying an AI system and audits regularly to make sure it's operating as planned, right? Do it often annually as a typical requirement, but even more regularly if needed. If, for instance, you're acquiring a company that uses AI, or this should be part of your due diligence. And of course, maintain documentation for regulatory inquiries and lawsuits in case you get into the discovery phase. And then, of course, we're mitigating the risks of AI harm is proportionate to the risks. And so I believe this concludes my portion of the CLE and the CLE portion of today's webinar. So for those of you who are seeking CLE, we've added the survey and the codes to the chat box, but we have another 30 minutes left in the webinar. And so I'm pleased to introduce Adeline Perron from Elix, who will be talking about the important topic of AI and sustainability. Adeline, the floor is yours.
Hi, everyone. First, I would like to thank you, Anne-Marie and Mathieu, for having me on the panel. I'm Adeline Perron. I'm not a lawyer, but I've been working in the intersection of technology, sustainability, and culture for more than a decade now.
Sorry, your camera stopped. We saw you at the beginning of the webinar, but not now. Sorry.
Can you see me?
Yes. Yes.
It's better? Yeah. That's a slide. Oh, next slide, please. Okay. So previously than Elix, I created an information platform for the art market, which included AI models that could predict the price of artworks up to 3 months in ahead for auction and private deals. In 2018, I exited the company and I joined Yassine and Casey to create the Elix Foundation. So our Paris-based foundation is called Elix, named after a character that you're going to see later on. And our Emirati-based company is named Future Culture, because for us, the future will be defined, will be shaped by sustainability in an SDG approach and will be like technical with fully of technology, including immersive tech and AI. Next slide, please. So before going any further, let me tell you the story of Elix. Elix is this character you can see. This is a digital character born 12 years ago in Paris that gained significant popularity and became one of the most followed accounts on social back in 2014. At that time, the United Nations, like many organizations, were seeking for a stronger presence on digital platforms. Elix was identified by that time, and after a 1-year trial period, where he went all over the world with the UN for the UN 70th anniversary, he became the first and still the only UN digital ambassador. And now on, we're working to give him more autonomy with the AI. Next slide, please. So the point I would like to share with you today is like AI is revolutionizing our approach to sustainable development. And that is good news. And you can see from the quote by Volker Turk, the UN Human Rights Chief, I'm not the only one believing in this. This is especially encouraging because we are like in a very unique period. We have never been so close to 2030, the target year for the Sustainable Development Goals. However, last year marked for the first time since 2015 that none of the 17 SDG showed progress. They all either stagnating or declining. Additionally, we find ourselves today in a period of renewed warfare, and this was underscored for us during the last December anniversary of the Universal Declaration of Human Rights, where suddenly it became a commemoration event led by the UN communication teams themselves. Next slide, please. Now I'm returning on a more inspiring and enthusiastic perspective. The reason AI is to set this revolution is because it will not just improve the way we do sustainability. It will it will fundamentally change the way we conceive, we act, and we value things. AI, and we think, and we can have the opportunity to believe that that we can be in a better way to fulfill the promises that all countries did in 2015 by adopting the 2030 agenda, creating a safer, fairer world for everyone, ensuring that no one is behind, while fostering a greater respect for the planet. And of course, in this process, it will cut carbon emission. But carbon emission is not the point. The point is more the SDGs. So that's why, oh, sorry, next slide. So that's why I've included 17 SDGs to refresh everyone's memory. What is important to remember is not like being able to code the 17 goals, but there are 3 key points. The first point is that SDG provide an universal and comparable framework for everyone, regardless your nationality or the organization you represent. The second point is that SDG address 4 main areas: environment and biodiversity, people and society, innovation and economy, and partnerships. And the third point is like SDG are supported by 169 targets, which interconnect all those goals. Together, they form a common matrix. Please, next slide. And in Davos, there is a think tank that gathered to work on this specific topic, AI and sustainability through the SDGs. And according to them, there are 3 key areas where AI has substantial impact on the SDGs. The first is improving the crop yields to improve more food without need to more extensive production. The second one is predicting diseases in advance rather than treating them after they emerge. And the third point is enhancing our understanding of biodiversity and protecting it not only from climate change, but also from illegal trade. Next slide, please. So what is interesting to add is that in all those challenges, I connected it to one single SDG. But when you look at it deeply, you can see that they are actually connected to many others. And I intersect truly the all SDGs. And if you, whatever the opportunity you want to tackle, like energy with a better smart grids, urban planning with the smart cities, or agriculture, as we previously mentioned, all the successes depend on a combination of various SDGs. And you always have the same one. For example, the partnerships are essential, which is SDG 17. Trustly governance as well, SDG 16. Fair business practice for all stakeholders, SDG 8. This is in addition to all the obvious SDGs that we all hear. This is why, actually, last year we conducted a mission for PwC France to establish a SDG method, which is what you have on screen now. We established several SDG methods for corporate and governmental strategy related to emerging tech, including AI. The goal of this SDG method was to measure the so-called good ideas in regard of the SDGs, because SDG provide this SDG footprint provide a more comprehensive and a broader footprint than a unique carbon footprint. And next slide, please. So AI is not just about cutting carbon emission or optimizing process. It's much more than that. It has the potential to achieve the SDG goals that we are to carry on until 2030. So next slide, please. So this is a fantastic picture, but there is another big challenge to realize it is an ethical challenge. So far, there is no clear answer. We know we need to have ethical eye to tackle this sustainable challenge, but we do not have a clear answer on how to do that. Only partial and incomplete answer. Beyond this element, there are like three main points that again come up. we need to integrate the 30 human rights into the AI design and governance. We need transparency and data privacy, of course. And also we need a global and multicultural collaboration and governance and be open to the whole world. That's why, next slide, please. I will stop being general and I will narrow to a country case. Next slide, please. I will narrow on the country I decided to move because, in my opinion, is going to pave the way to many interesting and innovative initiatives. The UI is a particularly interesting country because the country is at the front, is on the front line of climate change. In summer, it's 50 up to 70% humidity. Trust me, you cannot walk outside. Climate change is real and it's now. They have also a very high carbon footprint, similar to heavily polluting country. Like the US, they hit the overshoot day in March, and they have even a higher per capita emissions like countries such as the US. However, they are not the biggest polluters. The reason is really basic and very simple. The country is so young, it's 52. Before that, before the 70s, there were nothing. It was a desert. This historical perspective helps us to understand their agility and their cultural resilience. Here in UAE, nothing is taken for granted. None of it can stay forever. Everything is to be replaced. And also another thing interesting in UAE means no matter who you are talking to, they share the common belief that tomorrow will be a greater day than today. So if you go to next slide, please, they did something really interesting back to our topic. In 2017, they were the very first country to establish a ministry for AI, which aims at tackling challenging in a cross-cutting manner by integrating AI into climate policy, water management, and urban development. One of the main challenges is water supplies, as the country has no natural water sources and relies heavily on desalinizations. The real focus here in the UAE and more globally in the Gulf region is like switching to green energy, and AI play a significant role in the way they're moving to solar farm. Although pioneering initiative will be evaluated in 2031 at the end of the program launched by the AI Ministry. So I'm going to keep narrowing the scope, and if we go to next slide, I will speak about like I will speak about like a personal initiative like we're doing at the Helix. Sorry, next slide, please. Yeah. I'm keep narrowing the scope, as I was said, and because Anne-Marie suggested that I should share with you one of a current initiative, which is Archipel, is our current cultural program. We wanted to, next slide, please. We wanted to reinvent a fantasy world to approach all the complex topics that we have been dealing with, which are like on the sustainability challenges and all the tech and AI immersive tech challenges. And we wanted to tackle those complex and intertwined issues by emotion rather than cognitions. And that's why we choose a metaphor, which is archipel. Archipel is a French word for archipelago. I guess you got it. We love this metaphor because actually an archipelago exists in every continent. It exists geographically, but also in people, culture, and minds. There are like huge cultural work about archipel. And also archipel is a metaphor of the multilateralism. Now there is a UNGA in New York. And what is a big UN conference? It's gathering all those countries together to come on one agreement, on one common views. And also the third reason why we love the archipel metaphor is like because a small island and small island country, developing country, are the first one to tackle the climate change, and they are like common denominator for us to fight against climate change. So next slide, please. So what Archipel is about? Archipel is an immersive experience that will happen both in south of France in June and in November in Brazil. Why? For each edition, we are gathering NGOs that are working on the Mediterranean Sea and then on the Brazilian Sea to nourish the experience about their work. And the other side, we are going to help them because we are going to pull a carbon credit. What I'm telling you that is because the way we're using AI. We're using AI because actually we will never be able to produce so much content. It's like we produce so many kind of different contents, and we keep iterating them for both both the exhibition and the performance itself. So it helps us just is a basic for us. AI has become basic tool to realize our project. And secondly, it's more like personal. It's more like cultural views. It's like actually AI help us to create a new narrative, a new form of art. Next to performance, next to music, next to living art, next to traditional digital art, AI help us to create directly, and it's just like for us a new tool in our studio. And I'm not going further. I'm just giving this speech, and I thank you all for listening me, with a gift for not a gift for everyone here, but a gift for the ones that are now in New York. If you're in New York, I invite you to come at 4 p.m. New York time to the Expos Gallery in Ireland, where the Archipel performance called Metasia will be played by Yassine, and where the whole Archipel universe will be revealed. So you're all welcome at Expos Galleries online today at 4 p.m. That's it.
All right, well, thank you everyone who attended, and this concludes the webinar. Please feel free to reach out if you have any questions for myself or Anne-Marie or Adeline. Take care.